Hello, my name is Adam Risson. I'm the rewilding advocate for WildEarth Guardians, and I want to welcome everybody to our virtual PILC 2020 panel discussion on the Forest Service abuse of CE authority or Categorical Exclusion Authority. We have 4 presenters lined up for today. The first one out of the box is Marla Fox, and she is our staff attorney here at WildEarth Guardians. And she'll be talking about the general overview of categorical exclusion authorities, as well as some pertinent case law. And she'll also be giving a little bit of an overview of the proposed rule changes to CEs under the Forest Service's NEPA rule change. Next up, I'll give a little bit of an overview of some trends we've been seeing with the Forest Service's use of categorical exclusions. And then next up will be Mike Anderson, and he is the Senior Resource Analyst with the Wilderness Society, and he'll discuss the intersection between the use of CEs and the Roadless Rule. And he will also explain some of the proposed Forest Service rule changes and its intersection with inventoried roadless areas. And then finally, Ted Zukowski will wrap up, and he's the Senior Attorney with the Public Lands Program at the Center for Biological Diversity. And Ted will be giving some specific examples that we've been seeing that represent some of the most egregious uses of CE authority that we've been seeing recently by the Forest Service. And with that, I will hand this off to Marla, and we can get going with the presentations. Thank you.
All right, thanks, Adam. Just going to share my screen. All right. So starting with some legal authorities and just background on what we're talking about here. I'm going to start with the National Environmental Policy Act, since that's the umbrella statute that we are talking about today. And I include the legal citations here because this will qualify for continuing legal education credits if you're an attorney seeking that. And so starting just with NEPA and the general requirement that for a detailed statement for any major federal action significantly affecting the human environment. And so the idea of NEPA is for wise decision-making. It doesn't have substantive requirements, but it does have procedural requirements that has the twin purposes of fostering information sharing and decision-making so that both the government ensures that it's making a wise decision, but also so that the government lets the public know that it's considering the impacts of its potential actions. And so within a lot of what I'll talk about is within the Ninth Circuit, just because that's where a lot of our work focuses, recognizing that we do have, other circuit case law, but it was just easier for me to kind of cabin the scope of case law that I was going to talk about today. So within the Ninth Circuit, if an action may have a significant impact, then the federal agency is required to prepare an environmental impact statement, not just an environmental assessment. And courts have interpreted NEPA as requiring that this analysis take a hard look at the direct, indirect, and cumulative impacts of an action. So for the normal course of things, if there's a major federal action, you're going to be looking at taking a hard look at the impacts. And so a little bit more on the background, you've got, at least when we're talking about the Forest Service, kind of 2 sets of rules. You've got the Council for Environmental Quality rules with the citations here at 40 CFR. And then you've got the Forest Service rules that also implement NEPA at 36 CFR Part 220. Now, in the past year and a half, both CEQ and the Forest Service have proposed new rules or revisions to their rules. And so that's just something to keep in mind. On this screen, I have it noted that these were going to be those new rules are subjects of other panels at PILC. So hopefully those people will still be doing a webinar to delve more deeply into what those changes are. I will talk a little bit more about the Forest Service proposed new rules for implementing NEPA, specifically as it relates to categorical exclusions. But yeah, just kind of big picture, you've got NEPA and then the rules implementing NEPA, CEQs, and the Forest Services. So a categorical exclusion is a category of actions that are excluded from those NEPA procedural requirements. And so the definition of a categorical exclusion under CEQ's rules, the 40 CFRs, is a category of actions that will not result in individual or cumulative significant impacts on the quality of the human environment, and therefore do not require documentation in an EA or an EIS. The agencies can forego the need to do an analysis from the start because they have previously decided that a particular category of actions will not have a significant impact. And so it's set out in CEQ's regulations. Then you can further, so the agencies, at least the Forest Service, has identified categories, some categories by statute. Congress identified some categories by statute in the Healthy Forests Restoration Act, for example. HIFRA sets out at 16 USC 6951BA certain categories, but also the Forest Service itself has written rules identifying categories of actions that qualify for a categorical exclusion. And there's kind of 3 sets of CEs that I've listed here on the slide where the agency has gone through this analysis and said no significant impacts either individually or cumulatively through these actions. And the 3 categories within the Forest Service's CEs require different things. So at 7 CFR, at least right now, under the current rules, there's no decision memo required for those categories of actions. Then at 36 CFR 220.6D, those categories also do not require a decision memo, which would set out the agency's analysis for why it's not going to have a significant impact or why it qualifies under that CE. And then the third category is 220.6E, where there is a decision memo required. And that's important just for when I get to the proposed rulemaking, some of the changes that the agency is seeking about when notice might be required for actions with a decision memo or without. What else on categorical exclusions or for the rules? I think that's it for those. So just kind of keeping in the back of your mind that there's the statutory categorical exclusions, and then there might also be regulatory under the Forest Service's own rules. So thinking about challenging the use of a Forest Service categorical exclusion is, in general, I think an uphill battle. You start with arbitrary and capricious review under the Administrative Procedure Act, where the agency, has some, because it's the expert in implementing, or supposedly the expert in implementing its own statutes, it's an arbitrary and capricious review. But then on top of that, you've got deference to the Forest Service when it's implementing or interpreting its own regulations. And so that deference is the our deference. An agency's regulation will be deferred to by the court unless it's plainly erroneous or inconsistent with its own terms. And so that adds another layer of kind of difficulty in challenging the Forest Service's use of a CE because it's interpreting something that itself has written. Now, there's also this ongoing question of how much courts will defer to the agencies for an interpretation of its own rules moving forward, but that's, I think, much more up in the air. So kind of the current landscape is an uphill battle. So in talking about existing case law, I focused my review just on circuit case law because there's a wealth of district court case law and I just didn't have time to dive into all of that. And then I'm also focusing on the Ninth Circuit, as I noted before. So not only do you have this uphill battle, but there's been limited success in challenging the Forest Service's use of categorical exclusions, at least circuit court case law. This first one listed here, Forest Conservation Council versus U.S. Forest Service, provides a bit of what I think is foreshadowing on developing trends. In this case, the Ninth Circuit upheld the Forest Service's reliance on using 2 different CEs to approve logging on 14,950 acres. one CE was used for the roads and trails aspect of the project. And then another CE was used for building fence and utility lines on 3,000 acres. It was originally one project, right? And so this idea of using multiple CEs on one project to kind of parse it out and become insignificant or, to fit under categorical exclusion, it's been used before. This was a 2004 case. But I think what Ted and Adam are going to talk about is how the agency is taking that even further. We're starting to see them take it even further. So kind of foreshadowing there. In that case, I also wanted to note that the Forest Service had initially prepared an environmental assessment. It ended up preparing an environmental assessment for logging on 19,000 acres in the wildland urban interface in response to litigation. So there was a third aspect of this project that got pulled out, and they said, well, we'll do an EA on that. And so it mooted out the claim for using a CE on this an additional 19,000 acres. But the other two parts of the project, the court approved the use of a CE. The other case here is California ex rel Lockyer, and the Ninth Circuit rejected the Forest Service's reliance on a CE when the agency created the state petitions rule. And that was repealing the nationwide protections under the Roadless Rule. And I think this one's unique and doesn't really fit with these other cases looking at like site-specific use of a CE, because here the agency was trying to use a CE for a nationwide rulemaking, which is a pretty big action. And so that one, I guess, isn't a surprising outcome, but just wanted to note it in terms of like looking at overall case law regarding categorical exclusions. Two more cases, and then I'm going to switch to a different category. The first one here is Alliance for the Wild Rockies, a 2010 case. Again, the Ninth Circuit upholding the use of a categorical exclusion. And this was under 36 CFR 220.6 E13. So if you think back to those three categories of categorical exclusions under the Forest Service's own rules, you've got D and E. So E, I think, did not require a decision memo. And so just remembering where those fall in, because they're kind of different. There's different requirements for the analysis. But the action here was hand felling and helicopter removal on 242 acres. So a much smaller project, although it was helicopter removal, and it was on the Beaverhead Deer Lodge National Forest, Madison Ranger District. And then the fourth one here, Center for Biological Diversity versus Ilano. One part of this decision dealt with the Forest Service's use of a HIFRA categorical exclusion, so statutory categorical exclusion, for thinning and burning on 2,700 acres to combat beetle infestation. And so I think this is my personal interpretation, is that the use of a categorical exclusion under the Forest Service's own rules might be an easier challenge than a challenge to the use of a categorical exclusion under HIFRA, a congressionally created categorical exclusion, in part given the difference between a court rejecting an agency's interpretation as opposed to the court really challenging Congress's creation of categorical exclusion. So, and there's another layer for HIFRA in that the Forest Service needs to first designate a certain area as qualifying for HIFRA because it's subject to beetle infestation or fire. There's certain categories for HIFRA, but so once a landscape is designated for HIFRA, then they can start using the HIFRA CEs. And so I think that creates a much more difficult challenge to the use of the CE than it does under the Forest Service's own rules. And then this other section of case law, so those were all cases challenging the Forest Service's use of a CE. Then you've got case law dealing with the Forest Service's creation of a CE. And I bring these up just because the Forest Service's proposed rules, new NEPA rules, involve creation of new categorical exclusions or expansion of categorical exclusions. So if you're thinking about like, wow, those look kind of scary because it will expand the agency's scope, well, it's good to know what kind of case law exists in terms of challenging the creation of a categorical exclusion. And the first two here, one is in the Seventh Circuit and one is in the Ninth Circuit. Both of these cases, Heartwood versus Forest Service and Sierra Club versus Bosworth, both determined that creation or promulgation of a categorical exclusion is not a major federal action. So that rulemaking itself does not trigger the need for the agency to prepare an EA or an EIS for its new categorical exclusion. Which to me is important because when you're thinking about challenging the idea of a, categorical exclusion for a category of actions that in the cumulative might have a significant impact, if the agency doesn't have to do NEPA in creating that CE, when are those cumulative impacts actually required to be considered? It becomes it could become a catch-22 depending on how the court views future site-specific challenges to a CE. And then also noting that in Sierra Club v. Bosworth, although the agency said, or the court said that a CE is not a major federal action subject to NEPA, it rejected the Forest Service's proposed new fuel CE, which was going to be for projects less than 1,000 acres, up to 1,000 acres, or up to burning on 4.5 acres because it failed to assess the significance of the CE. So it didn't require an EIA or an EIS, but you still have to consider the significance under NEPA's rules for the definition of what a CE is. And then two more on challenging the Forest Service's creation of CEs. Colorado Wild Heartwood versus U.S. Forest Service upheld the agency's creation of a CE for salvage logging on less than 250 acres. So there weren't that many cases challenging creation of CE. So I just wanted to note that one, that the courts have and that's the 10th Circuit, courts have upheld creation of CEs, but it's a little more of a mixed bag. So we might have better success challenging creation of a CE rather than like future abuse or use of CEs unless it becomes super egregious. And then this final case, the Wilderness Society Inc. versus Ray in the 9th Circuit rejected the challenge to a new CE based on lack of standing. So don't forget, even when you're building all these administrative records and comments, et cetera, still have to have that basic Article 3 standing to get into the courthouse doors. Which can be challenging when you're looking at rulemaking that doesn't necessarily have an as-applied situation. Next, I was just going to mention, actually, Mike Anderson asked me to mention the policy changes that we're seeing at the Forest Service that kind of underlies some of the new trends that we've been seeing. So in May of 2019, let me just find my notes here. May of 2019, the Deputy Chief Chris French sent out a memo to regional foresters urging them to use categorical exclusions as the first choice and whenever possible. So really pushing the agency to make more use of categorical exclusions. And then Adam and Ted are going to talk about the trends that we are seeing both in increasing spatial and temporal use of CEs, also multiple CEs for one project. We're seeing some of these changes in how the agency is trying to expand the scope of these CEs. And then finally, I just wanted to touch on a few of the big proposed changes in the Forest Service's proposed revisions to its NEPA regulations. So in June of 2019, the Forest Service proposed to revise its NEPA regulations, and some of those revisions, actually a lot of those revisions, involved the categorical exclusions section. And so just to highlight some of the big changes, first here you can see the current regulations require scoping for all proposed actions, even if it's an action that they think is going to fall under categorical exclusion. proposed revisions are not going to require scoping or a notice for categorical exclusions without a decision memo. So that's that category D under 220.6. Second is what the agency refers to in its Federal Register preamble as clarifications on the use of CEs, but it's basically a green light to use multiple categorical exclusions, so multiple different ones on a single action with multiple activities, and you don't have to worry about the spatial and temporal limits of one on another. So let's say you have a project that's got up to 1,000 acres, and then another part of the project that has to do with road maintenance, the temporal and spatial limitations of one need not apply to the other, which that's kind of scary. And then it also creates a threshold that the agency must determine the likelihood of substantial adverse effects for extraordinary circumstances to exist. So one thing I forgot to mention earlier is even if the agency starts off and says, okay, we think this activity falls under categorical exclusion, if there is extraordinary circumstances that would pull the action out of a categorical exclusion and into the world of assessment under an environmental assessment or an EIS. And so under 36 CFR 220.6B1, there's a list of 7 resource conditions for extraordinary circumstances. And they include things like impacts to threatened, endangered, or sensitive species. So if an action is, involves impact, an action that otherwise would be covered by a CE involves impacts to certain resource conditions, then those are extraordinary circumstances that might warrant further analysis. And the new regulations are creating a threshold that makes it harder to get out of the world of the CE based on extraordinary circumstances. And then finally, it changes and adds categories of CEs in the sections D and E of the agency's own regulations. So it creates 9 new categorical exclusions, 2 in the category of D and 7 in the category of E, and then also expands some of the existing CEs spatial. A lot of it is the spatial limitations, so the number of acres allowed under a particular categorical exclusion for prescribed burning or things like that. It expands the scope of those CEs to allow for bigger actions to still qualify under a CE. So bottom line is you've got a lot of potential policy changes. Well, you've got the policy memo, you've got the proposed rules, and you've got what Adam and Ted will talk about in terms of new trends. And there's a lot of potential change coming that we are going to need you all to help with citizen oversight, because if we're not going to be seeing these CEs in notices and going out for public comment, we'll need citizen oversight all the more to be tracking what's going on in forests near you. So just a warning, Forest Watch is going to be all the more important as we move forward. And that's my presentation. So I'm going to stop my panel presentation and I'll mute.
Hey, can I bust in here and just underscore something
Please.
Marla said, which is that if there is no scoping on large categories of CEs, the first the public may hear about it is that the decision has been made. And so we won't even have an opportunity to create administrative record to build a case of why the CE should apply. So it's really seems like an attempt to insulate these decisions absolutely from citizen oversight and judicial review. So they're looking for ways to just bomb ahead on some of these projects without, getting their hands dirty with involving the public. At least that's my interpretation. Would you agree with that, Marla?
Definitely. Yeah, going back to the twin purposes of NEPA, and I mean, a lot of the comments that have gone in already to the Forest Service on its proposed changes highlight instances where the public have made a huge difference in identifying aspects of a proposed action that the agency wasn't even thinking about, and so, or didn't want to think about. There's definitely skepticism there on both sides of it, but just truly weren't even thinking about. And so highlighting the importance of notice to the public so that we can weigh in, yeah, and just cutting out the public voice will allow for so many things to go on under the radar, which I think is the overall intent, to just, it is to streamline, but it's also to cut out that public voice.
Thanks.
You're on mute, Adam.
Yep, thanks for that discussion. And those are very important points, especially as we get into the trends that we're starting to see under the current authorities. So keep in mind, as I present my presentation, this is what the agency is already doing, and it's seeking to do even more under the radar. And so with that, I will share my screen. And we can get going and looking at the trends in Forest Service abuse of authority. So I started off looking at every quarter, the Forest Service releases what is called the Schedule of Proposed Actions. And these are a list of all kinds of projects, including those it proposes under a CE. And here is a map on the Forest Service's SOPA website where you can actually navigate to each state and each forest and click on a forest and actually see its quarterly SOPAs. So looking at this past quarter, January through March, and based on a review of regions 1 through 6, I compiled a list of projects the Forest Service proposed some sort of vegetation management. Now there's a whole slew of categorical exclusions, and not all of them actually involve cutting trees. I tried to narrow my focus on burning, prescribed burning, and some kind of mechanical treatment for the use of CEs that I was tracking. And these would be CEs that actually have a decision memo. So those would be under category E, as I'll get into in a moment. But I also want to emphasize that this is not a perfect approach. Some projects appear on the SOPAs long after the Forest Service issues a decision, and then others fall off right after a few quarters. So some projects are just continuously listed for multiple years, and others just appear one time after a decision has already been issued because of the timing of a SOPA. It's quarterly. And so if a Forest Service project is put or proposed in January, a decision could actually be issued and then appear on the next SOPA. It's a little clunky and a little complicated, but it also shows some of the failure for actually tracking these CE projects. I also want to point out that some projects are placed on hold or canceled, and I actually didn't include those in my numbers. And then often the Forest Service doesn't even specify the number of acres it proposes or the authorities or authority it wants to use. And they wait until they actually make a decision before they put that in their decision memo. So overall, I just want to emphasize this is a course evaluation, but it does reveal some interesting and troubling trends. So Marla had mentioned the Healthy Forest and Restoration Act, and I was tracking two specific categories, that under 603, which is insect and disease, and 605 under wildfire resilience. These are two of the main sections for categorical exclusions, but they all have to tier back to section 602, that is experiencing or at risk of an insect or disease epidemic. So the Forest Service actually approved maps of where these epidemics could occur, and then 603 and 605 are categories that could take place within those 602 allocations. Projects typically have a maximum area of 3,000 acres, at least for now, and they cannot establish any new permanent roads. The Forest Service must provide a scoping period and issue a decision memo. Decisions are not subject to administrative review, meaning you can't object to it. And this is important because the public only has one opportunity to comment before final agency action. So any challenge would then have to occur in the courts. Now, in addition to the CEs provided under HIFRA, these 4 categories were the ones that I found the agency utilized most. Categories 12, 13, and 14 allow for a half mile of temporary road construction, and each provides other specific requirements. For example, category 12 precludes the use of clear cuts. It's important to note category 6 has no limits to the size of the project and provides the widest range of treatments from prescribed burning to commercial harvest, pretty much anything the agency deems as improvement. Now, these categories are not the only CEs that authorize treatments, just the ones that were the most common that I found in the SOPAs. So when I was looking at the SOPAs and tracking projects, I separated them out into Forest Service regions, and it's always a good to take a look at what the regions are. So as you can see, for Region 2, I included just Colorado and Wyoming and the Black Hills in South Dakota. The map provides a good reminder that Region 4 includes a portion of Idaho and Wyoming. And then Region 5 is basically California. So from the chart, you can see that there were 175 projects across 58 forests through regions 1 through 6. Now there's 74 national forests in all the regions combined, so some actually didn't have proposed projects this last quarter, but that doesn't mean they wouldn't have a project the previous quarter or the one coming up and starts April 1. Region 5 has the most projects across most of its forests because it has most forests, 14 out of 17 projects or forests had projects. So interestingly, Region 1 and 4 both had 30 projects across 9 forests, but you'll see the amount of acres between the two vary widely. And we'll get into the acres here in a moment. But first, let's see how these authorities break down. So here you can see combining 175 projects across all the regions. You can see most forests don't really specify the authority they're going to use. Rather often, the Forest Service just waits until the decision memo to list its applicable authorities. And obviously, this makes it difficult to determine if the agency's proposed action is even appropriate for the proposed authority because they don't tell us the authority. When the agency does specify the authority, you can see section 220.6 E6, and I'll just refer to it as E6, represents the one the agency utilizes most. And remember, that's the timber stand improvement or wildlife habitat improvement CE. When we look across, when we look at the categories by acres, you'll see why it's favored so much. In some instances, the Forest Service did list multiple categories, and I recorded the ones that were specific to vegetation management when they actually specified that. And it was difficult, again, to suss out which authorities matched which action because they really don't tell you. Even in the decision memos, it can be unclear. So breaking the authorities down into each region shows some interesting trends. Again, you can see most regions simply don't tell us what the relevant authorities they're proposing to use. And most of the time, these are the projects where the Forest Service also didn't list the acres. No surprise. Looking more closely though, regions 1, 2, and 6 utilized HIFRA and section E6 pretty evenly, but regions 4 and 5 clearly favor the E6 category over all others. Now, out of 175 projects, the Forest Service only specified acres for 134 projects. And these were typically project areas, not necessarily treatment areas. Where they did specify treatment areas, that's what I included in the number, but most often these represent project area sizes. You can see Region 4 by far has the most acres, and that is with 30 projects compared to Region 5 with 52 projects. Most glaring is the comparison with Region 1. It also had 30 projects, but nowhere near the amount of acres that we see in Region 4. But to be clear, Regions 4 and 5 have the most acres, but acres only tell part of the story. For example, in Region 1, out of 30 projects, 12 are all on the Nez Perce Clearwater National Forest, representing about 40% of all the projects in the entire region. Also, one project on the Custer-Gallatin National Forest proposed to treat anywhere between 500 and 5,000 acres annually for the next 10 to 15 years, and then had the caveat that it may exceed 5,000 acres where appropriate. So in other words, acres really do only tell part of the story. So looking again here, we can see how the project acres break down by authority. And this is just another graph to emphasize that E6 is the favored authority that the Forest Service likes to use. In some instances, the SOPAs did, or the project files did tell us the number of acres proposed, but then that didn't tell us the authority. So that's where that unspecified bar comes from. But again, it's not surprising that the authority with no limits on acres or time frame is the one that the agency prefers to use. And that just exemplifies why we see 3 million plus acres under the E6 category. And this is just another way to look at it. Seeing how this breaks down by region again shows that E6 authority is the most acres in regions 4 and 5. In Region 6 is unclear, primarily because most of the projects didn't actually list the authority when it did report the acres. So kind of, wrapping all this up, and the key takeaways here is that the Forest Service is using CEs to implement projects across millions of acres. In many instances, the Forest Service just fails to specify the acres or the authority it proposes until after it makes a decision, when it's too late to provide a comment. The Forest Service is just blatantly using that timber stand and wildlife habitat improvement CE, that E6, and it's basically using it as a blank check to propose multiple actions over a course of many years. Looking past the numbers, the project files we often see lacked enough specificity or evidence to prove a CE is even appropriate. These files fail to show there will be no significant effects to roadless areas or species of concern or any of the other extraordinary circumstances that could occur. Oftentimes, the Forest Service simply lists a bunch of mitigation or best management practices to prove that there will be no extraordinary circumstances. And the burden of proof is on us to try to say that those are insufficient. And then, of course, the agency gets deference. So challenging those is very difficult. Even though SOPAs are a perfect tool, it's the only one we have to track these projects unless we get on the mailing list for each forest or each district and ask to be notified of its proposed CEs. So there's got to be a better way to track the number of projects the Forest Service is proposing under CEs. And then lastly, when we do know about a project, it's really important to comment on that project. And I think that's a theme that all of us would like to emphasize during our presentations today. So with that, I will hand this over to our next presenter, and that is going to be Mike Anderson with the Wilderness Society, and we can get going. Mike?
Okay, just had to get off mute there. Let me share my screen here. Be with you in a sec. Hang on just a second. Let me try that again.
I think it's just at the end.
Okay. Let me go back to the beginning here. So this part of our panel is going to focus on Forest Service roadless areas. The roadless areas have a somewhat unique and special place in the National Forest legal history, and especially with regards to National Environmental Policy Act. So we thought it would be important to understand how the roadless areas are dealt with in terms of Forest Service legal protection, both substantively and procedurally. Just some key points overall about roadless areas. First, they cover a lot of the National Forest system, 58.5 million acres in total, which is about 30% of all the National Forest lands. Secondly, the roadless areas are currently protected from most road building and logging, and that is a substantive legal protection provided by the Roadless Area Conservation Rule since 2001. And thirdly, the Forest Service NEPA regulations provide additional procedural safeguards for the roadless areas. Not all Forest Service projects are covered by the Roadless Rule, and even for road building and logging, there are exceptions. And when those exceptions apply, we may need to fall back on NEPA's procedural requirements to make sure the roadless areas remain roadless. So first of all, what is a roadless area? Well, it's a tract of National Forest land, at least 5,000 acres in size, that does not have roads. And this was first spelled out in 1964 with passage of the Wilderness Act, which defined wilderness as areas with more than 5,000 acres that are substantially in a natural condition. The roadless areas became a major battleground in the National Forest, starting in the early 1970s and continuing through the late 1990s and beyond then. But during that 30-year period, 1970s, 80s, and 90s, there was a lot of litigation over roadless areas, and almost all of it involved National Environmental Policy Act, which at that point was a very new statute passed by Congress in 1969. And some of the very first cases involving NEPA, especially on public lands, specifically involved roadless areas. A couple of cases early on in the 10th Circuit over in the Rocky Mountains and mostly Wyoming, Parker versus United States, 10th Circuit, Wyoming Outdoor Coordinating Council, also 10th Circuit back in the early 1970s, established a lot of the basic NEPA ground rules for the Forest Service. And we were able to build upon those kinds of cases in the years afterwards to provide some interim protection for roadless areas. And then in the 9th Circuit, a couple of really important cases, Sierra Club versus Butts, 1972, which held that the Forest Service had to comply with NEPA and prepare an environmental impact statement for its nationwide roadless area review and evaluation process, or RARE. And subsequent to that, the Forest Service during the Carter administration prepared a second RARE called RARE 2. And in a major decision out of the Ninth Circuit called California versus Block, the Ninth Circuit held that the RARE 2 EIS was inadequate, and that the Forest Service really needed to do case-by-case, project-by-project, site-specific analysis of road building and logging projects in these inventoried roadless areas. So that was great victories with NEPA, and roadless area protection took place back in the 1970s and early 80s. And there was much litigation subsequent to those court cases, also legislation creating some wilderness areas out of the roadless areas. But for the most part, those roadless areas remained roadless, with some notable exceptions. Lost perhaps 1 million acres during that time out of Idaho. But perhaps, 90, 95% of the roadless areas that existed back in the 1960s and 70s remained roadless by the time we got to the end of the 1990s. At that time, at the end of the Clinton administration, there was a effort to provide substantive protection for the roadless areas to try to end the controversy that had been going on over roads, road building and roadless areas. And under the leadership of Forest Service Chief Mike Dombeck, the Forest Service adopted at the very end of the Clinton administration, the Roadless Area Conservation Rule. Subsequent to that time, there have been similar roadless rules adopted for national forests, roadless areas in Idaho and Colorado. But basically the same principles of substantive prohibitions on new road construction or reconstruction, and prohibition on commercial logging. Those are the two major threats to roadless areas, and the roadless area in general prohibited those activities within roadless areas. Didn't matter if you were trying to do an EIS, you just could not do those projects. But there are exceptions. There's allowance for road building, for hard rock mining, for public health and safety, exceptions for logging, for what's maybe called restoration thinning projects to restore more natural conditions into the roadless areas, and also logging when it is incidental to some other management objective. Let me just make sure I'm in right order here. Okay. Let's see. So let's turn over to the NEPA part of roadless areas. So since the 1980s, 1990s, the Forest Service has had somewhat special sub-rules for roadless areas within its NEPA regulations. First of all, there is a special sort of categorical inclusion, I would guess you might call it, for the Forest Service to do environmental impact statements for projects that would substantially alter the undeveloped character of an inventoried roadless area. And in about 2005, the Forest Service added or a potential wilderness area to that, that category. Those were areas that were identified as being roadless areas subsequent to 2001. They wanted to try to differentiate between the 58.5 million acres of inventoried roadless areas that are covered by the Roadless Rule and additional uninventoried roadless areas that were identified subsequent to 2001. So those were both covered under the Forest Service's NEPA regulations, which are currently still in effect. And this requirement has a pretty solid background of case law in the Ninth Circuit requiring EIS'S for roadless areas, inventoried roadless areas, and also uninventoried roadless areas. Smith versus Forest Service and Lands Council v. Martin being two of the more prominent Ninth Circuit cases. Now, also somewhat special recognition of roadless areas in the categorical exclusion part of the Forest Service NEPA regulations. As was discussed earlier, there are what are called extraordinary circumstances that prohibit the Forest Service from using a categorical exclusion in certain situations. And these extraordinary circumstances have been recognized by the Forest Service since back in the late mid-1980s. So one of those extraordinary circumstances is inventoried roadless areas or potential wilderness areas, just as was the case for the requirement to do a environmental impact statement in those areas when there's going to be substantial impact. If the Forest Service determines that there is not going to be substantial impact, they still have to potentially overcome this regulatory hurdle of it being possibly a extraordinary circumstance that would prohibit them from using a categorical exclusion for a project within a roadless area or a potential wilderness area. But it's not quite that simple. The Forest Service regulations don't say specifically that if you are in a project that's in a inventoried roadless area or potential wilderness area, that it automatically means you can't do the categorical exclusion. They require an analysis of the cause and effect relationship between the proposed action and a potential effect on the resource condition, which is the being in an inventoried roadless area. So being in a roadless area is considered a resource condition, and whether it is a categorical exclusion is going to depend upon that cause and effect relationship and also the degree of the potential effect of the action on the roadless area. So, and just to talk about a bit about the how the Forest Service's proposed changes in their NEPA regulations are going to affect roadless areas specifically. The big one is they are going to try to eliminate that EIS requirement in roadless areas. And, you know, that they're saying, well, the Roadless Rule has basically made this moot. irrelevant. We don't do road building and logging in roadless areas anymore because of the Roadless Rule. So we don't think we need to have this EIS requirement around anymore. Of course, what the Forest Service won't tell you is, well, if we decide to get rid of the Roadless Rule, such as they're proposing to do right now in the Tongass, well, that's too bad for the roadless areas that are not covered by the Roadless Rule. They'll be also exempt from this EIS requirement. But there's also quite a bit of case law that would argue that the Forest Service, does have to do EISs for major projects in roadless areas, regardless. And the second change that's being proposed is to get rid of this categorical extraordinary circumstance protection for the so-called potential wilderness areas. That is the areas that are roadless areas that were identified subsequent to 2001. So we are fighting that change, or both of those changes, and hopefully we will prevail. And just to mention also that there is a legislative policy action going on with in Congress right now with legislation that would essentially codify the roadless area conservation rule, give it statutory protection, because right now the Forest Service roadless rule is an administrative, substantive administrative protection that can be changed by the administration potentially, and that is, they've been changing it. They've changed it some for Idaho and Colorado, and now they are proposing for the very first time to exempt the Tongass National Forest entirely from the roadless rule in Alaska. So with that, I'm going to turn it back over to Ted Zukowski.
Thanks for that presentation.
Okay.
I would also just like to note that it's kind of disingenuous for the Forest Service to say that it's not going to do road building or logging in inventory roadless area when we see in its current proposed projects, that's exactly what it's going to do, as Ted, I'm sure you're about to explain.
Yes, and I think my presentation will borrow heavily from both Adam's and Mike's here, try to combine those and show you that the categorical exclusion that Adam was talking about that is most used, which is that E6 exclusion, is being, the Forest Service is now using those to try and approve gigantic projects over broad landscapes, over indefinite or long timeframes, in roadless areas with little site-specific disclosure, and where public involvement at the site-specific level is largely reduced to a post hoc exercise after the decision is made. So what the Forest Service is essentially trying to do is make almost forest-wide level decisions, or at least ranger district-wide level decisions, with virtually no review, no site-specific impact, and no public accountability. And I'm going to go through four sort of recent examples of specific CEs, and sort of tell you what the Forest Service proposed to do, why it's so egregious, so an egregious attempt to abuse these that CE on timber stand and wildlife habitat improvement, and what has happened with each of these proposals. So the first one I'll talk about is the Forest Health and Fuels Management Project proposed on the White River National Forest in Colorado. This is the area, the forested area around aspen, vale, and Breckenridge, so sort of classic Colorado Rocky Mountain high country. A lot of this area has been hit with a beetle kill in the last decade. And in December 2018, the Forest Service proposed the Forest Health and Fuels Management Project. And this would have allowed them to log 1,000 acres per year anywhere indefinitely into the future until significant changes in conditions warranted a new analysis. There was no description of what those conditions might be that might require the Forest Service to go back and review whether or not they wanted to keep logging 1,000 acres a year pretty much anywhere in the forest. They just wanted to be able to do this to undertake timely and flexible treatments. Again, they were going to use CE6, which is up there on your screen, as long as they don't use herbicides or require construction of 1 mile of low standard road. I think there's some questions remain about whether that means they can use temporary roads. I think we would argue that the temporary roads do fall under the definition of road construction, but there may be some fight about that. The Forest Service loves to construct what they call temporary roads, but they still have many of the same impacts as permanent roads. Now, conservation groups criticize this black box approach, arguing that the Forest Service provided no maps of where these treatments could be. The only limit was that they were going to be in overstocked lodgepole, which, when you don't define overstock, could include a lot of the sort of upper middle portion, elevation portion of the forest. They didn't describe when or where they were going to do these things. And if you're doing a project over 20 or 30 years, how are you even going to keep track of how much road you're constructing to know whether or not you've constructed up to 1 mile? So this really looks like a programmatic sort of condition-based approach. We're going to log this much under these sort of conditions. Maybe we'll tell you what those are. But the Forest Service said, really, you don't need to worry about the impacts here, because we'll after we've made this categorical exclusion decision, every year we'll go out on the ground and show you what we're going to do, and give you an opportunity to give us input. Well, that's, again, all that input is post hoc. It's after the decision has been made. There's no way to hold the Forest Service accountable for any promises they made. There's no requirement that they respond to your comments, as there is under NEPA. So it really was a leap first, look later, a blank check for the Forest Service. Now, so what has happened with this project? When groups around the White River raised these concerns, the Forest Service kind of grumbled and put the project on the back burner. So this one could come back, could be decided at any time, but for right now, it's on hold. Over in Utah, the next project we'll look at is the East Zone Fire Management Project. This is on the Uinta-Wasatch-Cache National Forest. This is sort of east and over the top of the hill from Salt Lake City. The Forest Service proposed this in August 2019 to address what they saw as a hazardous fuel issues there. They said that approximately 90% of the East Zone is dead timber, resulting in a higher than normal accumulation of hazardous fuels. Despite that fact, this project was not focused on protecting homes or around the wildland-urban interface. Again, it was to simply hasten the work of logging and burning where they wanted to. The landscape that they were looking at treating was nearly 1 million acres. The scoping notice did not disclose how many acres they would treat within that 1 million acres, where they would be treated, or for how long the agency was going to undertake the project. They didn't say the type of treatments they would use. They had a menu of 8 different types of treatments, but they didn't say which ones they would use where, under what conditions. And again, there was no, the site-specific treatments over this long period or indefinite period were not disclosed. Again, a blank check. And this time, huge amounts of roadless acreage were involved, 300,000 acres. You know, that's almost 500 square miles of roadless land, in which they said we can log where we want, when we want, as long as we only build 1 mile of, up to 1 mile of standard road. So how can they justify this? They basically said, you know, trust us because we know what we're doing. We've done 26,000 acres of projects in similar habitats over the last 10 years. That's 26,000 acres total. So we think we should have free reign to do these kinds of projects because we know what the impacts will be, even though they don't know where they're going to do them, when they're going to do them. And so that's highly problematic. Now, with the roadless issue, I think Michael talked about this, which is there is an exception that allows logging in roadless areas, but there are actually some standards in this exception, which is up here on the screen. First of all, if you're going to be cutting timber in roadless areas, it's expected to be infrequent. Now that's a pretty squishy term, but if you're logging in roadless areas over a 500 square mile area, a little bit every year over 20 years, that begins to perhaps push the boundary of infrequency. In addition, if you're going to do this, these kinds of treatments, the Roadless Rule really anticipated that what you'd be doing would be thinning trees to reduce fire risk. So the exception says that if you're going to do this kind of removal, or what's permitted in terms of logging under the Roadless Rule is the removal of generally small diameter timber, and you have to do it to maintain or improve roadless area characteristics. Again, some squishy terms there, but clearly you can't be just logging all the big trees there. The other thing that I think this stuff under subsection 1 here indicates is that there's got to be some kind of site-specific evaluation of what the impacts are going to be to the roadless area. And you don't get that when you allow the Forest Service, when Forest Service allows itself to log anywhere in any of the roadless areas over a 300,000 acre area. Without explaining what stands you're going to be cutting, what watersheds you're in, even what kind of trees you're going to be cutting. So these were issues that were raised in comments, and the Forest Service, the outcome of this one was the Forest Service actually sort of backed down. They said, okay, we're not going to do a CE that covers an indefinite number of years. We'll do a CE or 2 a year, depending on where we want to do these projects. And so the plus side of that is the public will get some kind of site-specific information about where these projects are going to be, which I think is helpful. And it means they'll probably be smaller projects. The minus side is that there's not going to be a cumulative look. We know that the Forest Service wants to go in and log a ton of stuff over a long period of time. And now we're only going to get information about it happening in dribs and drabs. So, an ideal outcome would be they would actually do a programmatic NEPA document, which they are clearly trying to get out of here. All right, on the third project is on the Ashley National Forest, and these are going to start to sound similar because they're all using the same categorical exclusion, and they're all using, they all involve roadless areas. This is actually just over the hill from the Uinta Wasatch Cache project on the Ashley National Forest. large swaths of aspen forest, which the Forest Service is worried is getting invaded by evil conifers, which need to be cut down, and are some of they're worried about fire suppression, limiting the health of some of the aspen stands. And again, huge project, 177,000. They said over this 1 million acre area, we can log any aspen stand anywhere, which is 177,000 acres of aspen on the forest. 130,000 acres of that are roadless. The initial proposal included clear cutting in addition to conifer removal. They didn't say how much they were going to try to log every year. They said it was going to last 10 to 20 years. Remember, forest plans under the National Forest Management Act only last 15 years. So this is going to outlive the forest plan that they're working on in that area. Again, they use the E6 categorical exclusion. And again, they relied on sort of past experience. You know, we have experience of this. We know what we're doing. We've done little projects, but now we want to do this massive one. This proposal is, conservation groups commented on it. The district ranger still wants to go ahead with the proposal. We spoke with her recently, and she tried to explain to us that they were going to put clear cuts off the table. They weren't going to be building roads in roadless areas. They're going to be using hand tools to the extent possible in roadless areas. They're going to be mostly burning in roadless areas. You know, to which our response is kind of, that's really nice. That's the kind of thing you should put in an EA. That's the kind of thing you should explain to the public. And when you just do these scoping reports for categorical exclusions, you do not provide the public with the level of detail to even understand what you're proposing. So that one is still pending. Finally, the Dixie National Forest, which is the southwest corner of Utah, near St. George, you know, sort of trending toward the road of Las Vegas. The Pine Valley Wildlife Habitat Improvement Project, again, humongous, 320,000 acres project area, 250,000 acres are roadless, with sort of vague project proposal, some logging, some burning. Not clear what's going to happen where, not clear how long it's going to take. Again, the same categorical exclusion that's being abused. And they say, well, you know, we've got this report from the Nature Conservancy that explains how we can get this area into a healthier condition because it's been overgrazed and it hasn't had fire in a long time, and we want to get fire back on the landscape. So, you know, that sounds like a reasonable kind of project. Or a reasonable project goal, but again, no information about what, you know, the what, the where, and the how of this project. So just again, another big old nasty project without the public being informed what they're doing. So what is the Forest Service up to here? Why are they doing this? Well, I think part of it is the Forest Service has sort of an institutional, you know, they feel they have expertise. I think you could, a pejorative term for it would be called hubris. They think they know what they're doing, and they don't really want the public to slow them down. And so that's why we're seeing these massive projects. That's why we're seeing the Forest Service move to change its NEPA regulations so that they can cut out the public, even from, you know, eliminating scoping from CEs so that they can issue these kinds of decisions without even informing the public beforehand. You know, the second reason they're doing this is because they can get away with it, because the language of that E6 exclusion is so broad that if they just, again, limit themselves with respect to herbicides and roads, they can log over an infinite area and an infinite length of time. President Trump also has made clear he thinks forests are for logging, issued an executive order that called for an increase, the cut on the national forest by 33% in a year. I mean, that's a huge push that the Forest Service is receiving from President and frankly industry as well, to get the cut out. And I think the other reason is, if you're going to do NEPA right, you actually do need to involve the public, and you actually do need to have trained staff who understand how to do it. It takes time, it takes money. And the most recent budget proposed by the president cuts funding for the Forest Service by 28% below the level it was funded this year, which means they're trying to do more logging with less money, which means you get cut out. Just sort of wrapping up. So what does this all mean? I think we're going to see more of these types of projects. If the NEPA regs, Forest Service and or CEQ regs get changed, we're going to see even more. As I alluded to, I think the more the Forest Service relies on CEs, the more opportunity there is for the public to misunderstand what the Forest Service is up to, because the Forest Service just isn't explaining very much. They're not telling you what the conditions are out there on the ground now. They're not telling you what they're planning on doing in the future. So there's going to be opportunities for the public to be confused. And I think there's likelihood for more litigation if we can figure out the handles. So all this means is watchdogging is going to be more important than ever on these forests. I think it always helps to not just know the ground and to know the paper so that you can comment on it, but also know the people, talk to your Forest Service district rangers, talk to the people who are putting these projects together so you can understand what you're doing and develop relationships and push back on them a little bit. Read your SOPAs, and you know, you only have one comment period, so that's why you really have to stay on top of those, the Forest Service notices for what's going on. And again, I think that the new rules are going to make this even, we're going to have to be even more on top of things. So thanks.
All right. Well, thank you everybody for these great presentations. There's a lot to unpack there, and appreciate the opportunity for the PILC organizers for us to get this up on their system. Hopefully this has proved useful. I know we're missing the Q&A section of the panel, so I will actually open it up to our respective panelists to see if there's any questions of each other before we sign off here. And I guess I will start by posing the question. I think you left it hanging there, Ted. It's what are the handles from an activist point of view that we need to do to create a good record to challenge these projects?
Well, I mean, I think where we have been successful in at least slowing things down at the administrative end before you get to litigation, it's when we have raised these kinds of questions. Tell us where, tell us how, tell us the baseline information. We've also raised, tell us how you can tell that you're not going to have harmful effects on the roadless areas when you don't know where, when, and how you're going to be logging in those places. You need that site-specific information to comply with the Roadless Rule. Raising all those kinds of questions. I think with the wildlife, one of the other things about this, the CE6, is that it's supposed to be for wildlife improvement. Tell us what wildlife habitat you're improving with this. Tell us how you're improving the stands. There is usually so little information provided in the scoping reports that they don't explain what they're trying to do or how they're going to achieve the goals, any goals with the treatments they're proposing. So take what they give you and dig in very carefully, I think is my recommendation. I welcome Marla, Mike, your thoughts, Adam?
That was going to be my response, is asking those questions, because the agency is the experts, or they are the experts. Like, they're usually the ones who should be answering those questions. And oftentimes, if the record doesn't contain that information, it forces them to take a step back and think about it. So rather than trying to become an expert yourself in every issue that might come up in a particular project, I found it to be really useful to just ask the questions and literally put a question mark in your comments. That's usually what brings out more information, I found.
Great. You know, I am going to do a time check here. I realize we're well over what we had wanted to spend, but I think maybe one more question, otherwise we can sign off. All right. Well, thank you again, everybody, for taking the time to hop on this afternoon, and we'll keep plugging away at it. Watch those SOPAs. Take care, everybody.
Thanks, Adam.
All right. Bye, all.
Right.